Now, to discuss this from the legal perspective, we are joined by legal analyst Mpumelelo Zikalala. A very good afternoon and welcome to Today on this Wednesday, Mpumelelo. This is a very bizarre story. Law enforcement officers off duty, one of them has killed the other. Allegedly, there's now a voice note making rounds on the social media that we listened, allegedly by the person who fired the 6 shots saying, I thought this person wants me to get out of the car. Had I gotten out of the car, I would have been shot first. So I had to shoot first. Obviously, I then need to ask you as a legal expert, when the day in court comes, would something like that stand?
It would depend on the other circumstances that are there and what was the subjective thinking of the person, and also the objective items that you're out there that you could obviously be able to see. Now, what you do see is someone who comes repeatedly towards his side of where he is sitting and tries and attempts to get him out of their vehicle. Now, the purpose of getting him out of their vehicle is certainly not to greet him, certainly going to attack him. So then the question would be, what other way could I have avoided that particular situation? If I drive away, he's going to shoot at the vehicle. So the only instance in which I have is to come back and say, I'm going to respond and defend myself in this particular manner. However, you must also take into cognizance that you are not dealing with a normal individual here, or simply a person who has gone to a firearms school, has received their competency training, and they come back. You are dealing with a member of the South African Police Service who has been trained as per the SAPS Act and also the Firearms Control Act, and have gained certain experience as to how to handle a firearm, how to disarm someone, how to make sure that you're able to defuse situations such as those ones. That is what our police are actually trained to do. And the most important question is that your service pistol, it is not used for attacking purposes, which is purely used for defense purposes. So that is what the court is going to have to decide, whether as you engage in those particular activities, the sequence of events that followed from there, did you utilize your service pistol to defend yourself, or did you utilize your service pistol to attack despite of the situation that you were faced with at that particular point in time?
And at face value, Mpumelelo, obviously we are now judging everything in the context of the visuals that are available and are going viral in social media. We don't know the context of how things could have escalated to where they did. Now someone has lost his life. Let's talk about the voice note that's making the rounds. Seemingly this person was sending this voice note to his colleagues explaining his side of the story. Will that jeopardize his case when he is now, in front of the magistrate and having to explain himself?
Not really. Just remember that the magistrate is only going to assess what has been stated under oath. So anything which appears on a statement, anything which is stated on a witness box is what is going to be considered by the presiding officer. Yes, you may consider whatever utterances that have been there, but I can assure you that his defense team will jump up and then say, you ought not to consider what has been stated in a voice note because it was not stated under oath. Evaluate evidence that has been submitted to you that can be corroborated. You have the person who's accused, if he's going to end up being charged, sitting right there in the witness box. You can ask and cross-examine him as to the situation that took place. Now, when it comes back to the cross-examination, as you perfectly stated, we only look at a few moments or a few minutes of the video. We don't know what happens prior. So the type of utterances or the words that were being said, the type of threats that have been there, any action or conduct that they might have acted prior to him getting into the car, the chances or the ability for him to run away to avert the danger, where the danger was still directed at him, of which if you look at that particular video, the danger was still there. You have a person who has a gun, who is a trained individual if you know where he works, and the person who's saying to you, get out of the vehicle because I want to talk to you. It is not going to be a social call. It is not going to be a social conversation that you're going to have. It is obviously going to be an attacking mode. And any reasonable person will then say, let me use this opportunity to try and defend myself. Maybe the manner of defending may have extended or crossed the Rubicon of the actual defense and went on the other side of attacking, but that is for the court to decide.
And when we talk about process, Mpumelelo, there is obviously time that is passing. Why have there not been any arrests made? Does that impact the case in any way?
It will depend on whether there are any investigations that have taken place. Now, if IPIT says we are on board, we're investigating the matter, then we must rest assured that they are going to investigate. Just remember, these are two police individuals that are both governed by the SAPS Act, even though the other one is a municipal official. So it's IPID that is the correct or the appropriate body to do those type of investigations. They are used to investigations in which their own members are involved, and they're going to try and make sure that they're able to boil down and find out what exactly happened. It is not wise to arrest or to say, I want to arrest an individual for purposes of investigation. It defeats the whole purpose. Rather, investigate, and after you have found out as to whether the person is innocent or guilty or not, based on the facts which are presentable to you, or on the prima facie evidence which is available to you, then you can arrest. So all that we need to do is to give them a latitude of time, make them do or allow them to conduct proper comprehensive investigation, and then they can come back, send whatever they have found to the NPA, and then say to the NPA, this is the situation, the facts that we've discovered. Is there a possibility of being able to prosecute this individual? If there is, can we be able to get a conviction? And if we can, only then we can arrest an individual and prefer charges upon them. But do not arrest for the purpose of investigation. That's not how things are supposed to be done.
Thanks for clarifying that, and that is a very important factor, if you will. Let's talk about, Mpumelelo, the fact that in the legal framework, is this something that usually happens where police officers would have fired shots at one another? We know, and I'll take you back to a case some years ago where these SAPS officers were on duty and the one fired the pistol, shooting the other behind the head. They were both facing the same direction. I don't know if you remember that. It happened in the East Rand. And I imagine IPID would have had some of their big think tanks on that case, right? But this in particular, these were now civilians who happen to be officers of the law. I mean, does something like this, have you dealt with anything of this nature in your legal framework?
I wouldn't say personally, but there have been instances in which these type of situations would occur, where a member, either of the SAPS or the Municipal Police Service, would use their service pistols in order to protect themselves or other to attack. And that's the most important question, which is then investigated by IPID in terms of saying who's at fault. That person who is at fault must then be prosecuted. But the bigger question then becomes this one: what type of training and continued skills development training are we giving to our police officers, both within the municipal level or within the SAPS, of saying that let's give you the emotional intelligence of being able to understand the powerful weapon that you possess in the form of the gun that you are carrying, regardless of the fact that it does not belong to you, it belongs to your employer. However, you are carrying a gun which is very lethal and it can cause an end to life. So we need to develop your emotional intelligence in terms of saying, when it comes to your anger levels, how you should understand certain individuals, how you should respond to individuals in which their anger levels have gone overboard or they cannot be able to control them. That's the type of intelligence and training in which I think we should be focusing on, and so that we do understand that if you are in a situation where you are given a firearm, it is not simply a purpose of saying that can you be able to utilize it so that you don't shoot innocent individuals, but do you know when to use it, do you know when not to use it. But most important, remembering these words, that a service pistol or any pistol for that matter, it is purely there to defend yourself and not to attack. So if you use it to attack, then you're inviting trouble in terms of the criminal prosecutions which are going to follow. I think it's something that the SAPS and also the Municipal Police Service have got to think about and say, what type of continuous training are we providing to our members to remind them every single time or on a regular basis as when to shoot and when not to shoot, and the type of emotional intelligence they need to possess in the number of situations that they are going to meet in the public, or when they are doing their on duty or even off duty as things may be.
In fact, speaking of that emotional intelligence, Mpumelelo, would the family of the deceased have any leg to stand on if they were to pursue a lawsuit? And who would they sue?
It would depend mainly on the report which is going to come from IPID in terms of saying, is IPID going to say, or if there's a criminal prosecution that takes place, was it based on self-defense or was it a full-on attack, which then becomes murder and not so something that can be defended. If you're able to suffice on that one and that person is found guilty, then it makes it easier to say, due to your negligence and not being able to use the emotional intelligence to gauge this particular situation, you've caused us harm. There was a father who was taking care of us, is no longer there. We've incurred funeral expenses, we've incurred general damages in terms of pain and suffering. Can you put us in a position that would have been had it been alive? We know that you can't bring him back to life. However, there must be some sort of compensation that must be there. Unfortunately, you can't sue the police because he wasn't acting within the course and scope of his employment. He was off duty. But when it comes to him personally, I think that's where the type of civil litigation can then go in. But the most important part is, and I always say this, do not sue or engage in any legal proceedings if you cannot get the money in which you are looking for. The court order that you are going to have is only as good if you are going to get the money in which you are seeking. If you have a court order that says you must pay 16 million rands, however, the person that you're seeking the money from does not have money, it means you've wasted time and money and even effort trying to seek something which cannot be effected. That's the most important question for me before you even of thinking whether you want to sue civilly or not.
That was legal analyst Mpumelelo Zikalala. Thank you so much for your insights. Very, very elaborate there at exactly